Sure, sir.
Ma'am, are you ready?
Yes, I'm ready.
Okay.
Good morning, everyone.
I will just give a little introduction and then you can proceed, ma'am.
Okay.
Yeah. Good morning, everyone. This is Dr. Kaushal Raj Upadhyay, Assistant Professor, Mehsana Law College. Today we are on a second day of International Seminar 2022. And we have with us Dr. Ilamala Dayal, Principal with the Sarvajanik Law College from Surat, and Priya Aristotle, Madam. She is an advocate on record, Supreme Court, New Delhi. And today we are ending the session after 4 lectures, and I welcome Ilamala Madam and Priya Madam on this virtual platform. Ilamala Madam will be giving a lecture on contribute holistic social transformation of India. So I request Ilamala Madam to deliver her speech. Ma'am, please.
Thank you for inviting me. Thank you, Kaushal sir, for coordinating with me. Sir, shall I begin? Have the participants joined?
You can proceed.
Okay, fine. I'll try to share my screen, okay?
Sure. Screen share करते हैं हमने.
My screen visible?
Yes, ma'am.
Okay, then I'll continue. My Indian judiciary towards holistic social transformation in India. Friends, topic is related to social transformation. Our judiciary has delivered ample of landmark judgments. I'm not analyzing those landmark judgments in this presentation. I'll be more or less concentrating on social transformation. Mahesh sir, before I continue, should I speak only in English or English, Hindi and Gujarati? What do you suggest?
Ma'am, you can go for all the languages, no issues.
I can speak a bit in Gujarati because some audience will be from Gujarat.
Sure,
also,
sure.
Right?
Sure. English,
Okay,
Gujarati and
thank you.
Hindi, ma'am. Ji.
Okay, thank you so much. So we will be discussing social transformation, which has been introduced in Indian society, mainly due to contribution of judgments delivered by Supreme Court of India. Sir, can it be an interactive session? Will other audience be able to answer back if I ask questions to them?
Ma'am, actually, thing is that it has only been broadcasting on Facebook and YouTube, so the
Okay.
participants will be
sir.
watching and listening you.
Okay, fine.
Okay, ma'am.
આપણે સોશિયલ ટ્રાન્સફોર્મેશનની ચર્ચા મેઇન કરીશું અને સોશિયલ ટ્રાન્સફોર્મેશન એટલે ખાલી નજીવા ફેરફાર નહીં, ગંભીર ફેરફારો, far reaching changes which have been introduced in Indian society due to judgments of Supreme Court of India. We all are aware about Montesquieu and Montesquieu's Doctrine of Separation of Powers. Montesquieu સત્તા વિભાજનના સિદ્ધાંત દ્વારા આપણને સમજ આપી કે ગવર્મેન્ટના 3 અંગો હોય છે, legislature, executive and judiciary, and all these 3 organs are separate. But when we have to bring about certain changes in the society, then all these 3 organs have to coordinate, try to support each other, aid each other, and then the changes of magnitude are introduced in our society. Montesquieu's Doctrine of Separation of Powers, and what I'm going to concentrate today on is that when there is legislative lacuna जब because of what do you say, certain lack in legislative provisions, and we are unable to protect the rights of citizens of India. At that time, judicial activism is much appreciated. जब हमारे laws कंप्लीट हमें रिड्रेसल नहीं दे पाते, जब हमारे अधिकारों का उल्लंघन होता है, तब न्यायिक सक्रियता की भूमिका ज़्यादा हम अप्रिशिएट कर सकते हैं. हम सबको पता है कि देयर आर 3 सोर्सेज ऑफ लॉ: लेजिस्लेचर, प्रेसिडेंट एंड कस्टम. ऐतिहासिक महत्व रूढ़िकर है एज अ सोर्स ऑफ लॉ. The best source of law today is legislation, વિધિ વિધાન. બટ જ્યારે કોઈના અધિકારોનું ઉલ્લંઘન થાય અને ધારાકીય જોગવાઈઓ redressal appropriate ન આપી શકે, કે રૂઢિ આપણી પાસે ન હોય કે આ ઇસ્યુનો આપણે redressal કેવી રીતે કરીએ, ત્યારે આપણે erstwhile સુપ્રીમ કોર્ટ સ્ટેપ ઇન કરે છે અને their landmark judgments definitely tries to give us a solution. પણ એક વસ્તુ આપણે બધાએ સમજવાની જરૂર છે કે it is too taxing an effort to create law de novo. કોઈ પણ કાયદાને તમે સ્ક્રેચથી એનેક્ટ કરો તો મેમ્બર્સ ઓફ પાર્લામેન્ટ માટે બહુ એફર્ટ એમાં જોઈએ, અને એફર્ટ કરતાં બી વધારે શું છે કે ફ્યુચરમાં કયા પ્રોબ્લેમ્સ આવશે એ કેટલા આપણે એન્વિઝન કરી શકીએ, બધા તો ન જ કરી શકીએ. એટલે કાયદાઓ કેવી રીતે ઘડાય છે, ક્યાં તો આપણે કોઈ બીજા દેશના એક્ઝિસ્ટિંગ સિમિલર લો એના પ્રોવિઝન્સનું એનાલિસિસ કરીએ છીએ, ઓર એલ્સ United Nations Organization, it will propose a model law for enacting similar legislations in member states, or our legislators are inspired and by the judgments of Supreme Court. તો હું પહેલા બે ઇન્સ્ટન્સીસ બહુ બ્રીફલી લઈશ કે યુનાઇટેડ નેશન્સની ગાઈડલાઇન્સ, અને એ ઇન્સ્ટન્સીસ પર વધારે કોન્સન્ટ્રેટ કરીશ કે જજમેન્ટ્સ ઓફ જ્યુડિશિયરી have influenced our members of parliament, members of legislators to frame laws, and those laws have introduced social transformation in our country. ફ્રેડમેનના વ્યૂઝ હું વર્બેટિમ અહીંયા કોટ કરું છું. The modern lawmaker can to an increasing extent influence and modify the social habits of the community. ફ્રેડમેને કહ્યું છે કે આજના જે આપણા આધુનિક સમયના ધારાશાસ્ત્રીઓ છે, મેમ્બર્સ ઓફ પાર્લામેન્ટ છે, લો મેકર્સ છે, તેઓ જ્યારે કાયદાઓ ઘડે છે તો આપણા વલણો, આપણી આદતો, આપણી સામાજિક આદતો, મેઇનલી સોશિયલ હેબિટ્સ ને ઘણું ઇન્ફ્લુઅન્સ કરે છે. આફ્ટર ડિમોનિટાઇઝેશન ફ્રેન્ડ્સ, આપણે બધા જ લાઈક મોબાઈલ એપ્સ યુઝ કરતા થઈ ગયા છે, ઓનલાઈન પેમેન્ટ્સ કરતા થઈ ગયા છે ફાઇનાન્શિયલ ટ્રાન્ઝેક્શન્સ માટે. સો ધીસ ઇઝ વોટ મોડર્ન લો મેકર્સ efforts, decisions which have influenced our social habits. આપણે હાલનો આપણો ગ્રાહકના અધિકારોના સુરક્ષાનો કાયદાની ચર્ચા કરીએ, કન્ઝ્યુમર પ્રોટેક્શન એક્ટ 2019. તો આપણો જે પહેલાંનો કાયદો હતો કન્ઝ્યુમર પ્રોટેક્શન એક્ટ 1986, અને આ કાયદાએ પોતાના સેક્શન 107 દ્વારા રિપીલ કર્યો છે. પણ જે કન્ઝ્યુમર પ્રોટેક્શન એક્ટ 1986 હતો એ આપણે કેમ ડ્રાફ્ટ કર્યો? બિકોઝ યુનાઇટેડ નેશન્સે 1985માં આપણને ગાઈડલાઇન્સ આપી મેમ્બર સ્ટેટ્સને કે દરેક મેમ્બર સ્ટેટે પોતાના દેશમાં ગ્રાહકોના હિતને સુરક્ષિત કરવા માટે આ મોડલ લોના અનુસંધાનમાં કાયદાઓ ઘડવાની જરૂર છે. આપણે 1986માં કન્ઝ્યુમર પ્રોટેક્શન એક્ટ 1986 ડ્રાફ્ટ કર્યો, અને ઇંગ્લેન્ડે કન્ઝ્યુમર પ્રોટેક્શન એક્ટ 1987માં ડ્રાફ્ટ કર્યો. એક રીતે આપણે આગળ વધીએ તો વી હેવ ઇન્ફોર્મેશન ટેકનોલોજી એક્ટ 2000. તો ઇન્ફોર્મેશન ટેકનોલોજી એક્ટ 2000 is the first cyber law of our country. આ એક્ટ મેઇનલી ઈ-કોમર્સ રેગ્યુલેટ કરવા માટે એનેક્ટ કરવામાં આવ્યો હતો. But this act also was influenced by United Nations Commission on International Trade Laws Model Law on Electronic Commerce of 1996. એટલે જ્યારે કાયદાઓ ઘડાય છે તો કાયદાઓ કંઈક ફ્રોમ સ્ક્રેચ આપણે નથી બધા જ ઘડતા. ઘણા બધા કાયદાઓ આપણે મોડેલ લોઝનું એનાલિસિસ કરીને ઘડીએ છીએ, બીજા દેશના કાયદાઓથી ઇન્ફ્લુઅન્સ થઈને ઘડીએ છીએ, ક્યાં તો જ્યુડિશિયરીના લેન્ડમાર્ક જજમેન્ટ્સથી ઇન્સ્પાયર થઈને ઘડીએ છીએ. હવે આજનો ટોપિક આ નથી, આ મારો મેઇન ટોપિક આજે જજમેન્ટ્સ છે. તો આપણે વી મૂવ ફોરવર્ડ. સોશિયલ ટ્રાન્સફોર્મેશન આખા વિશ્વમાં મેઇનલી કોમનવેલ્થ જ્યુરિસ્ડિક્શનની જે કન્ટ્રીઝ છે એમાં એશબી વર્સિસ વ્હાઇટથી બી ઘણું ઇન્સ્પાયર થયું છે. આપ સૌએ લો ઓફ ટોર્ટ્સમાં એશબી વર્સિસ વ્હાઇટના જજમેન્ટનું એનાલિસિસ કર્યું જ હશે. ઇંગ્લેન્ડમાં કિંગ્સ બેન્ચે 1703માં આ જજમેન્ટ આપ્યું હતું અને લોર્ડ હોલ્ટે ઓબ્ઝર્વ કર્યું હતું આ જજમેન્ટમાં. It is a vain thing to imagine a right without remedy, and want of right and want of remedy are reciprocal. ને આનાથી જ આપણે કહીએ છીએ કે આપણું જે લેટિન મેક્સિમ છે ઇન્જોરિયા સાઇને ડેમનમ, એનું આ એપ્લિકેશન આ કેસમાં જોવા મળે છે કે ઇફ યુ હેવ અ રાઇટ and somebody infringes your right, then you should have means to protect your right. આ કેસની અંદર ઘણા બધા વોટ ડુ યુ સે ઇશ્યુઝ વ્હાઇટના લોયર્સે રેઝ કરવાની ટ્રાય કરી કે તમે જો ઇન્જરી નથી, ડેમેજ નથી અને એને લીગલ ઇન્જરી સમજશો અને એને રિડ્રેસલ આપશો તો ઇટ વિલ લીડ ટુ મલ્ટિપ્લિસિટી ઓફ લિટિગેશન્સ. પણ લોર્ડ હોલ્ટે ડિસેન્ટ કર્યું. ધ મેટર વેન્ટ ટુ ધ હાઉસ ઓફ કિંગ્સ બેન્ચ અને પછી આગળ they decided in favor of એશબી. એટલે ઇન્જુરિયા સાઇને ડેમનમ, ઇન્જરી વિધાઉટ ડેમનમ. અને લો ઓફ ટોર્ટ્સને વન ઓફ ધ ફાઉન્ડેશન કેસમાં એશબી વર્સિસ વ્હાઇટ મનાય છે. એ જ રીતે ઇંગ્લેન્ડનું ડોનગ વર્સિસ સ્ટીવન્સન 1932નો કેસ આપણે લઈએ. એશબી વર્સિસ વ્હાઇટ પછી 200 વર્ષ રહીને આવેલો છે આ કેસ લગભગ. અહીંયા પણ યુ નો કે નેગ્લિજન્સનો આ ફાઉન્ડિંગ કેસ મનાય છે. that opaque બોટલમાંથી decomposed body of snail floats out. અને negligence, a specific tort of negligence has been acknowledged more prominently after the decision delivered in Donog versus Stevenson. હવે આ બે તો મેં ઇંગ્લિશ જજમેન્ટ્સ લીધા. આપણે સોશિયલ ટ્રાન્સફોર્મેશન ઇન ઇન્ડિયન સોસાયટીનું એનાલિસિસ જો કરવું હોય તો વી હેવ શાહ બાનો બેગમ એન્ડ અધર્સ, Shaira Bano, Nirbhaya case, and Vishakha versus State of Rajasthan. Friends, આમાં હું નોવાર્ટિસ, શ્રેયા સિંઘલ બધું એનાલાઇઝ કરી શકું, પણ દે આર લેન્ડમાર્ક જજમેન્ટ્સ. એનાથી ભારે ભરકમ સોશિયલ ટ્રાન્સફોર્મેશન્સ નથી ઇન્ટ્રોડ્યુસ થયા આપણા ઇન્ડિયામાં, એટલે હું લેતી નથી. ઇવન પુટ્ટસ્વામી, it is also a very important landmark judgment, but not a catalyst for introducing social transformation. એટલે મેં એ 4 કેસલો આઈડેન્ટિફાઈ કર્યા છે which are catalyst for introducing social transformation in India. શાહબાનો બેગમનો કેસ યુ ઓલ નો દેટ કે એનાથી બહુ ઇમ્પોર્ટન્ટ સોશિયલ ટ્રાન્સફોર્મેશન આપણા ઇન્ડિયામાં ઇન્ટ્રોડ્યુસ થયું છે. અને ધીસ કેસ હેઝ ઇન્સ્પાયર્ડ મેમ્બર્સ ઓફ પાર્લામેન્ટ ટુ ફ્રેમ ધ મુસ્લિમ વિમેન પ્રોટેક્શન એન્ડ રાઇટ્સ ઓફ મેરેજ એક્ટ 2019. હવે આ કેસનું જો આપણે ડીપમાં એનાલિસિસ કરીએ તો આ કેસ થ્રુ આપણે મુસ્લિમ વિમેનના રાઇટ ટુ એલિમોની અપહેલ્ડ કરવામાં આવ્યો છે. શાહબાનો બેગમના કેસનું અહીંયા વાત કરું છું. એટ ધ સેમ ટાઈમ આ જજમેન્ટ એ સમયે ફ્રેન્ડ્સ આવ્યો. We feel that this judgment was ahead of its time. It advocated personal laws. તમારા બંધારણના પાર્ટ 4માં ડાયરેક્ટિવ પ્રિન્સિપલ્સ ઓફ સ્ટેટ પોલિસી જે છે Emma, Article 44 advocates uniform civil code. So analysis of Shah Banu Begum no case kariye to it advocated introduction of uniform civil code quite earlier than people were prepared for it, in fact. અને આ જ કેસ એવો આપણે સમજી શકીએ છીએ કે શાયરા બાનો કેસને માટે ફાઉન્ડેશન લે કર્યું છે. Now we move on to Shaira Bano case. The triple talaq is now criminalized in our Indian society. આ કેસમાં જજમેન્ટ ડિલિવર કરતા પહેલા the judges have analyzed the practice of triple talaq in depth. They have analyzed Muslim personal law also before delivering this judgment. At the same time, international legal regime relating to rights of Muslim women, the practices of talaq, the personal law of Muslims have been analyzed in depth by the judges before delivering this judgment. એટલે આ judgment એવું નથી, it is a fluke. Lots of hard work has gone behind it by the judiciary. And then we are seeing this social transformation in India today. એ લોકો effects of the case, શાયરા બાનોના કેસમાં effects of the caseનું પણ analysis કર્યું. Petitionerનું જે marital lifeમાં discord હતું એના માટે. મુસ્લિમ્સમાં તલાકની જે પ્રેક્ટિસ છે એનું એનાલિસિસ કર્યું. મુસ્લિમ પર્સનલ લો માટે આપણા દેશની અંદર કયા કાયદાઓ છે એનું પણ એનાલિસિસ કર્યું. તલાક એ બિદત એટલે ટ્રિપલ તલાક ઇસ્લામિક અને નોન ઇસ્લામિક કન્ટ્રીઝમાં એની પ્રેક્ટિસ કેવી છે, ઇઝ ઇટ બેન્ડ, ઇટ ઇઝ કન્ટિન્યુઇંગ, એનું એનાલિસિસ કર્યું. અરબ સ્ટેટ્સની અંદર પર્સનલ લોઝનું એનાલિસિસ કર્યું. સાઉથ ઇસ્ટ એશિયન સ્ટેટ્સમાં પર્સનલ લોઝનું એનાલિસિસ કર્યું. તમે જજમેન્ટ વાંચશો ફ્રેન્ડ્સ તો આ બધા તમને ડિફરન્ટ પાર્ટ્સ જોવા મળશે. હા, આ જજમેન્ટની અંદર જ સબકોન્ટિનેન્ટલ સ્ટેટ્સમાં મુસ્લિમ પર્સનલ લોનું એનાલિસિસ કર્યું. જ્યુડિશિયલ જજમેન્ટ્સ રિલેટેડ ટુ તલાકે બિદાત એનું એનાલિસિસ કરવામાં આવ્યું. આપણા કોન્સ્ટિટ્યુશનલ પ્રોવિઝન્સ, કોન્સ્ટિટ્યુશનલ એથિક્સ તલાકે બિદત માટે આર દે ઇન ટ્યુન ઓર નોટ એનું એનાલિસિસ કરવામાં આવ્યું. એટ ધ સેમ ટાઈમ ઇન્ટરનેશનલ કન્વેન્શન્સ એન્ડ ડિક્લેરેશન્સ ઓન તલાકે બિદત એનું પણ એનાલિસિસ કરવામાં આવ્યું. એટલે ફ્રેન્ડ્સ, વોટ આઈ વોન્ટ ટુ કન્વે ઓવર હિયર કે ટુડે we have a Muslim Protection Act, a Muslim Women Rights Protection Act of 2019, which criminalizes the practice of triple talaq, talaq-e-bidat. But that act has been influenced by the judgments of Supreme Court in Shaira Banu case. And Shaira Banu case was in turn influenced by Shah Banu Begum's case also, which advocated the uniform rights of all women in India as far as right to alimony on maintenance is concerned. અને શાહ બાનુ બેગમ ના કેસ પછી જ્યારે આપણે શાયરા બાનોના કેસની વાત કરીએ છીએ તો શાયરા બાનોના કેસમાં જજમેન્ટ ડિલિવર કરતી વખતે the judges have undertaken a deep analysis of different practices in different countries of the world, Muslim literature, Muslim personal laws અને अपना constitutional provisions और उसके बाद ही judgment deliver करने में आया है. So social transformation of magnitude has been introduced by judgment of Supreme Court. निर्भया केस हम सबको पता ही है कि निर्भया केस के वक्त one of the accused was a juvenile less than 18 years of age. So the only impact was sent to juvenile home for 3 years. There was a hue and cry. Consequent social transformation ये हुआ कि जो हमारा जुवेनाइल जस्टिस केयर एंड प्रोटेक्शन ऑफ चिल्ड्रन एक्ट 2000 था उसको रिपील करके we have now juvenile justice care and protection of children act 2015. If a juvenile between 16 years of age now commits a heinous crime and the juvenile board is of the opinion that juvenile can be tried as an adult, then he will be made to face trial today as an adult. So ये social transformation after निर्भया's case judgment possible हुआ है. पहले ये नहीं होता था हमारे देश में, अभी हुआ है. निर्भया का जजमेंट करे तो उस एक्यूज को क्यों हमने पनिश एज एडल्ट? बिकॉज एक्स पोस्ट फैक्टो लॉ, आर्टिकल 20 क्लॉज ए ऑफ योर कॉन्स्टिट्यूशन, पार्ट 3 ऑफ योर कॉन्स्टिट्यूशन, के पिनल स्टैट्यूट्स का रेट्रोस्पेक्टिव इफेक्ट नहीं हो सकता, प्रोस्पेक्टिव इफेक्ट ही हो सकता है। रेयरेस्ट ऑफ रेयर डॉक्ट्राइन की हम यहाँ बात करें, बच्चन सिंह माची सिंह केस की थोड़ी मैं डिस्कशन करना चाहूंगी, थोड़ा निर्भया जजमेंट से अलग है, पर लेट मी ट्राई ओवर हियर कि अभी चाइल्ड मोलेस्टर्स को कुछ स्टेट्स ऑफ इंडिया में एडवोकेट किया गया है कि उनको डेथ पेनल्टी भी इश्यू करी जाए. So perhaps it is in tune with rarest of rare case in Bachchan Singh and Machi Singh. So again, जो social transformation हम इंडिया में देख रहे हैं, उसमें बच्चन सिंह वर्सेस स्टेट ऑफ पंजाब के केस का बहुत इम्पोर्टेंट कंट्रीब्यूशन है. माची सिंह वर्सेस स्टेट ऑफ पंजाब के केस का बहुत इम्पोर्टेंट कंट्रीब्यूशन है. बच्चन सिंह का जजमेंट आया, उससे पहले क्या ट्रेंड था हमारे देश में कि फॉर grievous offenses, heinous offenses, capital punishment was the rule and imprisonment for life was the exception. But after Bachchan Singh's case, the judgment has been clarified that for serious offenses where you can give punishment of murder or imprisonment for life, imprisonment for life will be the rule and murder will be the exception. And this ratio of Bachchan Singh has been highlighted in Machi Singh versus State of Punjab. We move forward. We talk about Vishakha's case and consequent social transformation in our country. We all know Vishakha's case has influenced the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013. हमारे सब लॉ कॉलेजेस में, सब इंस्टीट्यूट्स में आज इंटरनल कंप्लेंट कमिटी is very active, and that guidelines we have received from Vishakha's case. अगर विशाखा का केस का हम एनालिसिस करते हैं तो ये PIL अंडर आर्टिकल 32 फाइल की गई थी, and we all know UBJS IB remedium, where there is a right there is a remedy. And these guidelines served their purpose till the act in 2013 was drafted. ओके, नाउ ये जो केसेस मैंने डिस्कस की हैं तो उसके कंक्लूजन की तरफ अगर हम आगे बढ़ रहे हैं तो सुप्रीम कोर्ट ऑफ इंडिया ने शाह बानो केस से एक पॉजिटिव इन्फ्लुएंस हमारी सोसाइटी में जनरेट किया है, विच हैज लेड टू द कल्मिनेशन ऑफ द 2019 एक्ट. निर्भया केस से जुवेनाइल जस्टिस एक्ट पूरा रिपील होकर रीड्राफ्ट हुआ है, री-एनेक्ट हुआ है. Vishakha ki guidelines have protected working women in workplace till the act has come into force. Legislation is considered to be the superior most source of law today, friends. But members of parliament, legislators are definitely influenced by precedent. ये हम डिस्कस कर सकते हैं बिकॉज मैंने आगे जब शाह बानो केस के बाद 2019 एक्ट फ्रेम हुआ तब उस बिल का डिस्कशन लोकसभा में हुआ था और उसके कुछ पैराग्राफ्स मैंने यहाँ रिप्रोड्यूस किए हैं, आगे जाके हम वो बात कर सकते हैं. दूसरी बात मैं आपको यहाँ ये भी डिस्कस करना चाहूँगी कि जब सुप्रीम कोर्ट डिसीजंस जजेस देते हैं तो दे आर इन्फ्लुएंस्ड बाय फॉरेन प्रेसिडेंट्स आल्सो. यू नो, जो डिसीजन सुप्रीम कोर्ट ऑफ इंडिया देती है they are binding on the lower courts in our country, but the decisions of foreign courts are not binding on our Supreme Court. Yet हमारी Supreme Court वो केसेस को जो दूसरे कंट्रीज के कोर्ट्स ने दी हैं उसका भी एनालिसिस करती है, एट टाइम्स उनको भी अपने जजमेंट में इनकॉर्पोरेट करते हैं. So those cases only have persuasive role, but still they are considered by our Supreme Court. हम आगे बात करेंगे तब वो सब भी मैं यहाँ इंक्लूड करूँगी. ये जो केस लॉ है, स्पेशली हम बात करें तो शाह बानो के केस का, तो जो डिस्क्रिमिनेटरी पर्सनल लॉज मुस्लिम वुमेन के लिए इस देश में थे उनको रेगुलेट करने के लिए इस केस की इम्पोर्टेंस है. मैंने जो फॉरेन प्रेसिडेंट्स की बात यहाँ फ्रेंड्स की है, तो ये लिस्ट ऑफ केसेस मैंने आपके साथ यहाँ शेयर किया है. अगर टाइम मिले और शाह बानो बेगम का केस, सारे शायरा बानो का केस आप रेफर करो, तो शायरा बानो के जजमेंट में ही ये सब केसेस आपको दिखेंगे. यू हैव चीटर वर्सेस कैटर, यू हैव अस्काइन वर्सेस अडाना. There's a list over here. I'm not repeating the entire list. But जब शायरा बानो का केस हमारे जजेस डिलीवर कर रहे थे, जजमेंट डिलीवर कर रहे, तो उन्होंने फॉरेन प्रेसिडेंट्स का एनालिसिस किया और उससे इन्फ्लुएंस और इंस्पायर होके ये जजमेंट डिलीवर किया है. विशाखा का केस की आप बात करिए अभी, तो दिस जजमेंट हैज गिवन अस गाइडलाइंस फॉर प्रोटेक्टिंग वुमेन फ्रॉम सेक्सुअल हरासमेंट एट वर्क प्लेस. जब सेक्सुअल हरासमेंट एट वर्क प्लेस का मैटर आया, तो अवर जजेस केम टू नो कि there are no legislative provisions for protecting the rights of working women, so they gave us the guidelines. ये बहुत शॉर्ट जजमेंट है, अगर किसी ने पढ़ा हो तो, hardly 4 to 5 pages of your Supreme Court cases or AIR. और इस जजमेंट में कंप्लीट ड्राफ्ट ऑफ बिल दिया गया है. गाइडलाइंस आर इन अ फॉर्म ऑफ अ बिल इफ यू हैव गॉन थ्रू इट. कुछ ऑथर्स इसे जुडिशियल लेजिस्लेशन कहते हैं. जब आप विशाखा का केस पढ़ो तो आपको ध्यान आएगा इसमें भी ऑस्ट्रेलिया के हाई कोर्ट का जजमेंट रेफर करने में आया है. मैं वो जजमेंट यहाँ वर्बैटिम रिप्रोड्यूस कर रही हूँ. आई एम सॉरी, मैं म्यूट नहीं कर पाऊंगी, दूर पड़ा है वो फोन. एक केस की अब बात करें तो हाई कोर्ट ऑफ ऑस्ट्रेलिया एंड मिनिस्टर फॉर इमिग्रेशन एंड एथनिक अफेयर्स टेक वाज रिकॉग्नाइज्ड the concept of legitimate expectation of its observance in the absence of contrary legislative provision. और यहाँ हमारे जो जज हैं वर्मा साहब, उन्हें कहा है कि हमारा जजमेंट बाइंडिंग क्यों रहेगा, बिकॉज जब तक सूटेबल लॉ फ्रेम नहीं होता रिलेटेड टू प्रोटेक्टिंग राइट्स ऑफ वर्किंग विमेन, ये जजमेंट बाइंडिंग रहेगा. और वो उन्होंने कहाँ से लिया है? ऑस्ट्रेलिया के केस से लिया. ये केस का ऑब्जर्वेशन भी आपको विशाखा के जजमेंट के गाइडलाइंस में ही मिलेगा. वहाँ बोला है कि हमारा जजमेंट को आपको फॉलो करना पड़ेगा जब तक कि प्रॉपर लेजिस्लेशन प्लेस में नहीं है. ओके, हमारे लेजिस्लेटर्स ने जब 2019 का मुस्लिम वुमेन का एक्ट ड्राफ्ट किया, दे हैव बीन इन्फ्लुएंस्ड बाय शायरा बानोस केस. जब उन्होंने 2013 का वुमेन के राइट्स को प्रोटेक्ट करने के लिए केस ड्राफ्ट किया, दे हैव बीन इन्फ्लुएंस्ड बाय विशाखास केस. अभी मैं 2019 की लोकसभा डिबेट्स यहाँ वो बैटम रिप्रोड्यूस कर रही हूँ, वेरी स्मॉल पोर्शन ऑफ इट, जहाँ द मेंबर्स ऑफ पार्लियामेंट हैव एक्नॉलेज्ड that they have been influenced by the judgments of Supreme Court. श्री जयदेव गाला गंटूर से थे. उन्होंने कहा है this 2019 bill is a consequence of Supreme Court judgment in Shaira Bano versus Union of India. It set aside the practice of talaq-e-bidat. यानी यहाँ वो एक्नॉलेज करते, इसलिए हम ये बिल पास कर रहे हैं. श्री अनुभव ने भी एक्नॉलेज किया कि the government has decided to support Supreme Court judgment through this bill, and this is an admirable clause. श्रीमती अपराजिता ने भी acknowledge किया, this bill is a logical culmination of verdict given by High Honorable Supreme Court in Shaira Bano's case in 2017. I must say this historic judgment was a step forward towards liberating Indian Muslim women. So अब देखिए कि मेंबर्स ऑफ पार्लियामेंट जब वो बिल बना रहे हैं, तभी वो लोग डिस्कस कर रहे हैं कि हम जजमेंट से इन्फ्लुएंस होके ये बिल पास कर रहे हैं. अब तक के हैदराबाद में 50 ट्रिपल तलाक केसेस रिपोर्ट हो चुके हैं. मैंने 2-3 महीने पहले ये स्टेट्स निकाले थे, कल मैं नहीं निकाल पाई. और सूरत के अंदर ट्रिपल तलाक अटेम्प्ट करने पे इन लॉस को बुक करने में आया था. आगे केस का ऑफिशियल रिपोर्टिंग मेरे पास नहीं है अभी. अभी हम थोड़ा आगे चल के, ये हमने बात की 2019 के एक्ट की, थोड़ा आगे चल के बात करें तो यू टॉक अबाउट 2013 एक्ट एंड यू कंपेयर इट विथ विशाखा का जजमेंट ऑफ 1997. तो यहाँ कंपैरिजन में मैंने दिया है कि 2013 के एक्ट का सेक्शन 2N उसको आप जजमेंट का पॉइंट नंबर 2 के साथ कंपेयर करो तो डेफिनेशन ऑफ सेक्सुअल हरासमेंट इज सेम इन द जजमेंट एज वेल एज द एक्ट. अभी 2013 के पार्ट 8 का सेक्शन 21 को आप कंपेयर करो. एनुअल रिपोर्ट गवर्नमेंट को सबमिट करना होता है इंटरनल कंप्लेंट्स कमेटी के द्वारा. तो गाइडलाइंस पॉइंट नंबर 7 में मिलेगी आपको विशाखा के जजमेंट में. So yes, we can say that the acts are influenced by Supreme Court judgments and in turn they introduce social transformation in our country. But friends, यहाँ मैंने थोड़ा लिमिटेशन हाईलाइट किया है कि जुडिशियल प्रोनाउंसमेंट बाय इटसेल्फ will not be able to introduce holistic transformation in our society. इसके लिए हम 239th रिपोर्ट ऑफ डिपार्टमेंट पार्लियामेंट्री स्टैंडिंग कमेटी का देख ले तो उन्होंने क्लैरिफाई किया है कि सेक्सुअल हरासमेंट ऑफ वुमेन एट वर्क प्लेस इज ड्यू टू विशाखा's जजमेंट. बट उनका एक रिकमेंडेशन हम यहाँ ले रहे हैं उसी रिपोर्ट का कि लेजिस्लेशन हमने बहुत देर से फ्रेम किया. 1997 में जजमेंट है, 2013 में लेजिस्लेशन है. उस ड्यूरेशन में सिर्फ गाइडलाइंस वर नॉट इनफ टू प्रोटेक्ट ऑल द वुमेन एट वर्क प्लेस. लेजिस्लेशन हो, सैंक्शन का डिटरेंस हो तो शायद ये एक्टिविटीज जो वुमेन के राइट्स को इन्फ्रिंज कर रही है एट वर्क प्लेस रेगुलेट हो पाती है. यानी जजमेंट इटसेल्फ विल नॉट गिव होलिस्टिक सोशल ट्रांसफॉर्मेशन. इट हैज टू बी सपोर्टेड बाय मीनिंगफुल लेजिस्लेशन ऑल्सो. ये रिपोर्ट से हम हाईलाइट कर सकते हैं. एंड में हम अब्बास नकवी यूनियन मिनिस्टर ऑफ माइनॉरिटी अफेयर्स उनका थोड़ा ऑब्जर्वेशन देख लेते हैं. So many Muslim countries Islamic countries in the world have declared triple talaq as illegal. Egypt, Sudan, Bangladesh, Syria, Morocco, UAE. But हमें 70 years लगी ये practice कब करने में. So that was a drawback on our Indian society. Or I thought it will be an interactive journey. I'm sorry for this quote. I end this journey by quoting Naqvi again today. So many cases of triple talaq have come down, have been reported also after the 2019 Act. So this social transformation has been introduced by the judicial judgment and supported by appropriate legislations. With this, I rest my case. Thank you. Are you there, Dr. Upadhyay? I have done. Dr. Upadhyay, Dr. Mahesh. Yes, sir. Yes. Yes, sir, you're audible. Yes, sir. So I can hear you. Yes, sir. Yes, yes. Yes, sir. Concluded. Concluded. Okay, sir. Uh, shall I leave? Okay. Okay. Okay, fine. Then I'll continue for a while. So.
Yes. Yeah. Am I audible, Kaushal sir? Okay, okay. So on the same link, I need to deliver the session, and it's okay. But I need to present a presentation. So whether I should, so I'll be sharing with you. But could you please give your mail ID so I can share on your email? For that, I need to join on another mail ID, because I'm connected with my mobile, and the presentation is in on laptop. So yes, but see, that I can understand that you slides the presentation, but my laptop camera and mic is not working properly. So I'll be delivering the session through my mobile, and the presentation will be from laptop. So, okay, fine, no issue. I'll share the link on my mail ID, and we'll also present the presentation through laptop. I'll, I'll do it. Just a minute. joined from two devices, na? Hello. Yes. Am I audible properly? So I'm going to share the slide. Going to- Okay. So is it visible? Okay. The slide is properly visible, na? Okay. Fine. 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 Thank you so much, uh, uh, sir, and warm wishes for all the best for your this international conference. Though it is second day of your conference, but thank you so much for giving me this opportunity to deliver this session. And see, the topic the topic is right to privacy and forensic science, and I hope the slide is visible to all. So okay, so before we proceed, we need to understand the topic is right to privacy and forensic science and its applicability for that court proceeding. So we need to understand the science behind the forensic science. So, forensic science as a tool for assisting in the detection of crime and helping the criminal justice system, because the ultimate goal is to get justice and to deliver justice in a proper manner. Now, forensic science it is also useful to under trial prisoner to get speedy justice. Forensic science is a multidisciplinary study which draws on physics, chemistry, biology, computer science, psychology, and phonetics to name a few. And forensic science scientists strive to find methods and solutions for recovering and collecting evidence from crime scene, ensuring that criminal justice or criminal evidence is recovered and retained without being contaminated or altered, packed, and sent into scientific and safe manner to the forensic science lab, where the latest techniques are deployed and applied to extract prosecutable evidence that will link the evidence to the perpetrator. Now, as a society progress towards a more scientific approach to crime solving that is more in line with today's human rights environment, forensic scientists will continue to play an increasingly essential role in the process. Here in slide, you can see that forensic is attempting to apply a host of invasive technologies upon suspect in any attempt to excise truth and lies directly from their body. So forensic psychology vital in detecting even terrorist case, and nowadays the digital forensic is also, rapidly used in through technology. So, narco analysis. Majorly, I'll be focusing. So far as right to privacy is concerned, narco analysis, brain mapping, fingerprinting, fingerprints. There are very much essential, and the nuances lies before this test has to be understood in such a manner that right to privacy is also enshrined under fundamental rights, and which need not to hamper even through such court proceeding. So it gets certain immunity as it is mentioned under these fundamental rights. So narco analysis and brainwave fingerprinting can reveal future plans of terrorists and can be deciphered to prevent terror activities. Preventive forensics will play a key role in countering terror acts, forensic activism, solution, and better crime management. Certain forensic scientists or certain jurists, they have given the definition for this particular technology. So forensic science is the application of natural science to the procedure of law. In practice, the subjects of forensic science draw its principles and methods from the subject like physics, chemistry, biology, and other science subject. So here you can see the California Criminalistic Institute has defined forensic science as forensic science is the application of the methods and techniques of the basic science to legal issues. Forensic science is a very broad field of study, and it includes crime laboratory scientists, sometimes called forensic scientists, or more properly criminalists, work with physical evidence collected at the scene of crime. If we look into the introduction, so we need to understand right to privacy before we proceed towards forensic science and its applicability in the criminal justice delivery. So privacy deals with individual privacy under Article 21, and which needed to be protected earlier before K.S. Puttaswamy versus Union of India in 2017, as it was previously not considered as a fundamental right under the Constitution, but later on, after the verdict of this particular, it was well considered as that right to privacy as a fundamental right. And Black's Law Dictionary narrate that right to privacy means right to be let alone, the right of a person to be free from any unwarranted interference. So there is even no interference of law as such. If we talk about the scope of forensic science, and then the area of forensic science is so vast and complex that it has evolved into necessary working horse for the criminal justice system. And nowadays, it would be some up to certain extent more easy to catch the culprit or criminal with the help of forensic science and to protect our criminal justice system. So in India, the current state of criminal investigation and prosecution is before it very you can say a pretty terrible. A substantial majority of trials in India results in acquittals. For this, we have both official and unofficial figures with us, and the disposal ratio or conviction ratio is somewhat not that much, you can say, handsome. So when it comes to official figure, it's around 90%, and the unofficial rate is significantly higher. So the investigation of crime and the prosecution of those who perpetrated them are not up to par in India. Even in shocking crimes, a large number of offenders are not punished, and a small percentage of cases result in acquittal, resulting in an increase in the number of criminals and crime against society. I mean to say crime against a nation, crime against human. So these recurrent acquittal are mostly due to antiquated investigative process. Thus, for actual investigation, scientific ways of investigation is essentially, is very much necessary. And with this background, see, when it comes to right to privacy in ancient Hindu texts, the concept of privacy can be pragmatic. Taking a look at the Hitopadesh, we state that some issues such as religion, sex, or family matters should be kept private. In ancient time, privacy was linked to, you can say, positive morality. And when it comes to modern India, right to privacy discussed first time in Constitution Assembly by K.S. Kamudini, and right to privacy, which was described, it was proposed by K.S. Kamudini, but Dr. B.R. Ambedkar only gave it the full support, and right to privacy was not included into Indian Constitution when it was framed. Since the 1960s, the subject of privacy has been addressed both as a constitutional right and as a common law right. In 1954, in the case of MP Shah versus Satish Chandra, an 8 judges bench of the Supreme Court, while dealing with the power to search and seize documents from the Dalmia group, dismissed the existence of a right to privacy on the basis that the makers of the Constitution did not consider right to privacy as a fundamental right. Otherwise, they have incorporated this very right from the beginning of the Constitution. So, on demand of a private existence, made a comeback before a 6 judges bench in the panel after 10 years, about in the case of Kharak Singh versus state of Uttar Pradesh. You can see here. And the Supreme Court ruled that while there is no basic right to privacy, the clause allowing night visitation was invalidated and infringement of a personal liberty. And Justice Subbarao dissented. He stated that the right to privacy is still an important component of human liberty, despite the fact that it was not integrated or defined as a basic right in the Constitution. So the cases you can see here. Just a minute, I'll make it comprehensive. So yes, is it visible properly? Okay. Kharak Singh versus State of UP rejected the right to privacy as a fundamental right. In Govind versus State of Madhya Pradesh, and in a 3 judges bench of Supreme Court, faced with a similar factual matrix, held the existence of a fundamental right to privacy under Article 21. After 11 years, even though Govind lost privacy tempered for the first time and received most respect under the Indian Constitution's personal liberty clause. Then K.S. Puttaswamy versus Union of India, privacy, it was considered as the privacy has become ingrained in our fundamental right. At this time, it has never faced such severe challenges to its existence as it did before the 9-judge bench in case Puttaswamy versus Union of India case. What if we talk about right to privacy and life and liberty, we need to understand at the same time what exactly the life. So a critical question is raised. Why? studying the relationship between Article 19 and Article 21 during emergency as to whether there existed a natural law, right to life and personal liberty after the suspension of Part 3 of the Constitution of India during the emergency period. So in ADM Jabalpura versus Shivkant Shukla, the Honorable Supreme Court held that there existed no right to life and personal liberty beyond Article 21, and the state has power to suspension of certain rights during the period of emergency. So along with right to privacy, we need to understand what is personal liberty. So Fifth and 14th Amendment, even in US Constitution, gives the term liberty, and later on we have also incorporate this term. So a fairly broad definition which encompasses all the liberties that a human being is expected to possess. In contrast to the US Constitution, Article 21 qualifies the right to life and liberty by a personal life, which implying that our Constitution's scope of liberty it less than the US Constitution. Aspect of right to privacy, we see the phone tapping and privacy issue in Ram Malkani versus State of Maharashtra and PUCL versus Union of India. So it guaranteed right to privacy is not guaranteed right under our constitution, but whenever it comes into the play before the Supreme Court has favored this particular right in otherwise. The Supreme Court decision to give Article 21 a new dimension in the post-Manka period is an interesting development in Indian Constitution, constitutional law. Article 21 is at the heart of the fundamental right, and as a student of law, as a teacher of law, I considered Article 21 as a backbone of fundamental right, and of course, fundamental rights is a core part of constitution or constitution. So, Article 21 has proven to be a multifaceted document. The expansion of Article 21 dimension was made feasible by giving the word life and liberty under Article 21, which has broader connotation. These are organic concepts, and even jurists consider this concept is an organic concept which should be interpreted in meaningful way, in broader way. Article 21 of the Constitution of India states that no person shall be deprived of his life and personal liberty except according to the procedure established by law. And after Maneka Gandhi's judgment, procedure should be due and fair. So the court has implied the right to privacy from Article 21 by interpreting it in conformity with Article 12 of the Universal Declaration of Human Rights 1948 and Article 17 of the International Covenant on Civil and Political Rights 1966. But see, both of these international documents provide for the right to privacy, as we discussed with the help of these case studies. So this scope of this right first come up under the consideration in the case of Harak Singh, which was concerned with the validity of certain regulation, the permitted surveillance of the suspects. The minority decision of Subba Rao deals with this particular rights. when it comes to narco test and narco analysis, so though Article 21 right to life has been widely interpreted to the entail more than simply survival existence or animal existence, as a result, it encompasses all aspects of life that make a man's existence more meaningful, complete, and worthwhile, and the right to privacy is one of them. The Supreme Court held in Kharak Singh versus State of UP that regulation 236 of the Uttar Pradesh police regulation was unconstitutional. One can even state cannot levy surveillance on the suspects because it conflicts with Article 21 of the Constitution. The right to privacy is an element, necessary element of the right to life and personal liberty, according to the Constitution. And in so far as this forensic tests are concerned, a normal person can easily manage to lie by using his imagination in normal situation and in normal condition. So the narco analysis test is a highly specialized test that firmly neutralize the person's imagination, as after narco dose, person goes into semi-conscious state. In the semi-conscious state, it becomes difficult for him or her to lie. Rather, he or she answer most likely only truth and facts, what he or she already knows. So when it delivers, or the truth serum delivers to a person, it is too difficult to say lie, but it shall be see, when narco analysis or certain test commands, it need to take prior permission from the respective courts. Narco analysis is one such scientific advancement that has become a more and more prevalent term in India. Narco analysis is a diagnostic and psychotherapeutic technique that use psychotropic drugs, particularly barbiturates, to induce oblivion or coma, in which mental elements with strong associated effects come to the surface, where they can be exploited by therapists. Narco analysis derived from the Greek term narc, meaning anesthesia or torpor, and it is attributed to describe a diagnostic and psychotherapeutic technique that uses a psychotropic drug, particularly barbiturates. Here you can see the pictures. So how it is done is very much essential to understand. To Horsley, this particular term coined by Horsley, who is narco analysis. Narco analysis poses several questions at the interaction of law, medicine, and ethics. It is procedure for narco analysis is violative of the rights against self-incrimination guaranteed under Article 20 by 3 of Constitution, and it is even prohibited. It provides immunity to an offender or accused, because no one can compel to give to be a witness against him or herself as per the immunity. If we talk about narco analysis from constitution and legal standpoint, confession made by a semi-conscious person are not admissible in court. Hence, such examination are generally not allowed. However, after analyzing the circumstances, in which the test was taken, the court may award limited admission. So basically, sodium pentyl or sodium amytal, it was, incorporate in the body of a person whose narco is going to be, tasted, and it is basically known as a truth serum. So, in one of the case, the petitioner claimed that the court could not order the prosecution to conduct narco analysis or brain mapping or lie detector test against the accused will, since it would be a violation of Article 20, sub proviso 3 of the Constitution, Article 20, Indian Constitution, and Article 20 is the most important section concurring criminal inquiry and trial. The privilege against self-incrimination is a fundamental canon of common law of criminal jurisprudence. Under Article 20, sub proviso 3, which embody this privilege, that is, no person or accused of any offense shall be compelled to be a witness against himself. Subjecting the accused to undergo the test, as has been done by the investigative agencies in India, it is considered by many as blatant violation of Article 20, sub proviso 3. It was held that torrent of the Constitution of India. The use of narco analysis test raise a fundamental dilemma about a judicial matter as well as on the ground of human rights. The legality of using these techniques as an investigative tool raise serious concern about infringement on a person's right and freedoms and liberty. In the case of her state of Bombay versus Kattikalu, it must be demonstrated that the accused was forced to make a statement that was likely to incriminate him. Compulsion is defined as the threat, beefing, or imprisonment of a person's wife, parent, or kid as a result, where the accused give a confession without being concerned. So, yes. When it comes to polygraph again and brain making, teams of experts shall be required. Before narco test or such test like brain mapping or polygraph, the court shall be, one has to take permission from the respective courts, and one court is approved this sort of cases then and then. But the team of experts shall be there, in which clinical forensic psychologist, psychiatrist, physician, anesthetist, audio videographer, writer, and many of the cases like Arushi Talwar's case, and then Nithari mass killing case, it was well considered by court that narco analysis test will be commenced. So it is well established that the right to even silence has been guaranteed to the accused by the virtue of pronouncement. In the case of Nandini Satyapati versus P.L. Rani, no one can forcibly extract statement from the accused, who has the right to keep silence during the course of interrogation. By the administration of these tests like narco analysis or certain lie detector, or so forcibly intrusion into a body or into one's mind is being restored to, thereby nullifying the validity and legitimacy of the right to remain silent. In this Nandini Satyabhati versus P.L. Dani's case, she claimed that she had a right to silence by virtue under Article 20 of Proviso 3 of the Constitution and Section 161(2) of CRPC. The apex court upheld the pleas. Moreover, the tests like narco analysis are not considered very reliable. Studies done by various medical associations in US adhere to the view that the truth serum do not induce truthful statement, and subject in such a condition of trance under the truth serum may give false or misleading answers sometimes. So expert team has to be there, and it should be in the form of question answer. In USA, in the case of Trosen versus Sain, it was held that the petitioner's confession was constitutionally inadmissible if it was adduced by the police questioning during the period when a petitioner will was overborne by a drug having the property of a truth serum, likewise under narcotics. And through this process, collecting evidence and helps into the investigation does not amount to testimonial compulsion. So thus it does not violate the constitutional provision regarding protection against self-incrimination. Narco analysis in India, a few democratic countries, India most notably, still continuing to use narco analysis, which is not openly permitted or banned for investigative purpose in most developed and democratic countries like us. If we see the procedure of narco analysis, which includes the following points, which is to be considered like a pre-test interview, pre-narco state of mind, state of his question answer ability, then semi-narco test, post-test interview, and along with this section 161 of the CRPC, such person shall be bound to answer truly all questions relating to such case put to him by such officer, other than questions the answer to which would have a tendency to expose him to a criminal charge or a penalty or forfeiture. But even though a person shall be bound to answer truly, which is a bit contradictory with the immunity under fundamental rights of Article 20 by Proviso 3. So when it comes to Indian criminal justice, it catches the attention of media and critics, thereby raising several issues regarding its validity as a scientific tool of investigation and its admissibility in the court of law, infringement of individuals' fundamental rights, and questions its value as an evidence. In India, the narco analysis test is done by a team comprising of an anesthesiologist, psychiatrist, a clinical forensic psychologist, an audio videographer, and other supporting nursing staff. The forensic psychologist will prepare the report about the revelation, which will be accompanied by a compact disc of audio-video recording. The strength of the revelation, if necessary, is further verified by subjecting the person to polygraphic and brain mapping test. Narco analysis is steadily being mainstreamed into investigation, court hearings, and laboratory test analysis in India. Yes. So when it comes to legality of narco analysis test, here you can see no person accused of any offense shall be compelled to be a witness against himself. It provides immunity against the self-incrimination. So, but still, some of the cases it has it catch the attention through media, even in public domain, and it helps our criminal justice system. So in Arushi murder case, court held validity of narco analysis test as unconstitutional, but still it was the particular case it was permitted. Lie detection test come under the general power of investigation under section 160 and 167 of CRPC. But it must be realized that it is prerogative of the person to allow him or herself to be put to polygraphic test or not, and it should not be left to the discretion of police unless it is allowed by law. It must be seen as illegal and unconstitutional. In Nithari serial killing case, court did not admit the result of the test later on, and it is being refused. But see, the logic behind the narco analysis test, if it is conducted with free consent of the person, it may be permitted by his or her own will. It is called free consent. Means it is voluntarily, and it is not given under coercive circumstances. Voluntariness can be understood by the example if a person says that I wish to take a lie detector test or a narco analysis test because I wish to clear my mouth. I wish to clear my stand. I wish to clear my reputation. So this logic mostly, prevailing behind to go for narco analysis or certain lie detector or brain mapping or polygraphic test. It shows his or her voluntariness, but it is still to be shown that whether this voluntariness was under coercive circumstances or not. If a person is told by police, if you want to clear your mouth, if you want to clear your name, if you want to clear your reputation, take a lie detector test. The most reason given by police while investigation or investigative process. Or take a lie detector test and we will let you go. Then it shows that police has linked up the freedom to give with the lie detector test, and as such it cannot be held voluntary. These kind of statements are held to be self-incriminatory. Now, when it comes to admissibility in the court, while narco analysis provides a wealth of information, it also raised numerous questions with several detractors expressing deep concern about the use of serum on witness to extract the truth, which relates to the investigative process. Narco analysis is used to collect and support evidence as a tool or help, but it cannot be the sole basis of conviction or acquittal. However, questions have been raised as to whether it constituted to judicial testimonial compulsion and a breach of, you can say, human rights, individual liberty, and freedom. Lawyers are even a split on whether the result of narco analysis and P300 tests are admissible in courts as evidence, claiming that admission made by a semi-conscious person are not. Admissible, because while delivering administer of this sort of chemical into a person's body, it directly affect to a person's mind, and the person, if the person is in semi-conscious, the words spoken by him can whether considered or not. That is again a question before the court of justice. So in India, narco analysis was first used in 2002 in Godhra. I have mentioned that particular case over here. Let me check once. Okay, fine. But yes, 2002 in the Godhra carnage case, it was also in the news after the famous Arun Bhatt kidnapping case in Gujarat, wherein the accused had apprehended before NHRC, National Human Rights Commission, and the Supreme Court of India against undergoing the narco analysis. It was again the news in Telgi stamp paper scam, when Abdul Karim Telgi was taken to the test in December 2003. Though in the case of Telgi, immense amount of information was recovered, but doubts were raised about its value as an evidence. Again, in the Bombay High Court, in a significant verdict in the case of Ramchandra Reddy and others versus State of Maharashtra, upheld the legality of the P300 or brain mapping and narco analysis test. The court also said the evidence produced Nandini Satyavati, the case I have mentioned, but it is not here. Okay. So the court also said the evidence produced or procured under the effect of narco analysis test is also admissible in this particular case. However, defense lawyer and human rights activist viewed that narco analysis test was very primitive form of investigation and third degree treatment, and there were legal lapse with interrogation with the aid of drug. Narco analysis in the limelight in context of famous Nithari village serial killing. The two main accused in this particular case was in the killing. The name Mohinder Singh Pandher and Surinder Kohli have undergone narco analysis test in Gandhinagar, Gujarat itself. In 2006, the Supreme Court of India stayed the order of Metropolitan Judge to conduct narco analysis on K. Venkateshwar Rao in Krushi Cooperative Urban Bank case. Then it is also criticized in certain way that narco analysis, that the narco analysis is not 100% accurate. It has been found that certain subjects made a totally false statement during even this particular after the administer of truth serum. It is often unsuccessful in eliciting truth, as such it should not be used to compare the statement already given of the police before use of drug. And sometimes it is not, question are not well framed. So the exact information which need to be extracted from the subject is again in the question. So it has been found that a person who has given false information false statement even after administration of certain drugs. It is not much help in case. It is very difficult to suggest a correct dose of drug for a particular person because the amount of certain drugs may be might be vary a person to person, or the status of his mind or the ability to extract those drugs which vary again. So the dose of drug will differ according to willpower, mental attitude. The goal only injection is not required for a successful narco analysis test. A knowledgeable and skilled interviewer who is trained in posing recent and successful question is necessary for the test success itself. The goal of a narco analysis test is to resort memory that the suspect had forgotten. If the test is used to obtain confession for crimes, the outcome may be suspect. As a tool for criminal investigation, narco analysis is not suggested. Narco analysis may be beneficial in medical settings, such as treatment of psychotherapeutic disorder. The test should not be utilized in a criminal investigation unless the suspect give his or her consent. And narco analysis is particularly useful when it is necessary to elicit information in order to prevent terrorist offense, even if it is in criminal justice system, credibly it as at risk. Narco analysis has the potential to develop into a realistic and successful alternative to cruel third-degree procedure. However, it is important to ensure that the method is not misspelled or abused by the investigating officer, and that it is utilized in conjunction with corroborative evidence. So it is not, to say the sole basis for conviction or acquittal. NHRC has come up with some of the guidelines with the forensic science investigative techniques that no lie detector test should be administered except on the basis of consent of the accused. An option should be given to the accused whether he wishes to avail such test or not. Then and then after investigative agencies with the help of, with the approval of court, they may go for certain tests. If the accused volunteer for a lie detector test, he should be given access to a lawyer, and the physical, emotional and legal implications of such a test should be explained to him by the police and his lawyer. So he need to again to be understood the grounds and the physical, emotional and legal implication, and then it should be administered. The consent should be recorded before a judicial magistrate. During the hearing before the magistrate, the person alleged to have agreed should be duly represented by a lawyer. So lawyer or a to represent him or herself shall be there, or with his consent it should be administered. At the hearing, the person in question should also be told in clear terms that the statement that is made shall not be a confessional statement. That like I confess the offense or certain in that manner. So a statement to the magistrate, but we have the status of a statement made by the police during the investigation. Then the magistrate shall consider all factors relating to the detention, including the length of detention and the nature of interrogation. The actual recording of the lie detector test shall be done by an independent agency and conducted in the presence of lawyer. So the procedure or the entire process shall not be biased one. So it is again, well mentioned in the NHRC, or NHRC has mentioned or come up with certain guidelines. So admissibility of expert evidence. Under section 45 of Indian evidence, court need expert to form opinion on foreign law, science and art, identity of handwriting, identity of finger impression, electronic evidence. So this, with the help of the science and technology, narco analysis, brain mapping, and lie detector test cannot be conducted on accused without his consent, else it would violate Article 21 of the Constitution. In the past, forensic science was used to solve the Nithari case. Forensic expert had to examine hundreds of bones and skeleton remains as well as perform psychoanalysis study in order to reconstruct and devastation. A complete psychoanalysis during the Nithari case, the Kohli was done in addition to DNA matching to better understanding in the narcophilia, Philadelphia, and paraphilia tendency. So again, to club with narco analysis, brain mapping, fingerprinting, print and DNA profiling, it should be permission given by a court or court of trial. Then and then it shall be administered, and voluntariness is also be there of offender or accused whatsoever, and then one can go for that narco analysis test. So new scientific technology helpful in detecting lie, crime and the criminal. Still ambiguity regarding role played by the forensic evidence to help the court's arrival at logical conclusion. Approval needed for legal use of narco analysis, polygraphy and brain mapping. There are several cases afterwards. To 2002, then 2006 in Nithari case, then Abdul Kalim Telgi. So the analysis of this forensic investigative tools and technique reveals that the advantage in conveyance of justice without any delay. Forensic science is an evidence procedure which comprises several branches of science. It consists of forward thinking and contemporary medical technologies and rapid advancement of medical technologies. It shall be, easy to get some sort of evidence. Law is a dynamic process that evolves in response to changes society, science, ethics, and other factors. Science-related innovations and improvements should be incorporated into the legal system as long as they do not violate fundamental legal principles and are beneficial to society. Only a few democratic countries, most notably India, still use narco analysis, and in India, use of narco analysis test as a method of integration has been hotly disputed. The level to which it is recognized in our judicial system and society will become obvious in the not too distant future. Supreme Court decision interpreting Article 20 sub proviso 3 because what is at issue is India's committed to individual freedoms and a clean criminal justice system. The central government must take a clear policy posture on narco analysis. There have been orders of various high courts upholding the validity of narco analysis still. These judgments are in stark contrast with the earlier judgment of the Supreme Court interpreting Article 20. The central government must make a clear policy to stand on narco analysis, because what is at stake is India's commitment to individual freedom and a clean criminal justice system. And the validity of narco analysis or such sort of forensic science investigative methods are sometimes at stake. So the legal system, Indian legal system, is based on the fact that a person is innocent until proven guilty. Also, our legal system pleads to save an innocent, even the life of 100 criminals is at stake. Thereby, it needs to seek the help of technology to make this happen even a more efficient manner. So, summing up the presentation and the session as well, and I would like to ask a question, if any, from your side. Yes. So I'm done, and the floor is open for the question. If it no issue, because it will. Yes, 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 I understand. So I hope I finish the session in time. Okay. Okay. Thank you. Thank you so much, sir. So indeed, my pleasure. Okay. So may I sign out now? Okay. Thank you. Good day, sir. Wish you all the best for successful completion of the examination. Our wishes are there. And convey my regards to all participants and all stakeholders of the international conference, and last but not the least, the organizing committee and team and the principal, who is very much active in this sort of international conference and academic endeavor. Yes, please. Thank you so much for providing me such an opportunity. Thank you.